The law of settlement: how to redeem what's already yours. One. The hidden bond game. In every court case, there's a bond behind the curtain. Most people never see it, but it's there, an insurance instrument guaranteeing the proceeding. Think of it as a backstage pass to the financial side of justice. Every case has its price tag, an appearance bond, a performance bond, even a reinsurance bond that underwrites the whole show. So what does that actually mean? It means the court isn't just about guilt or innocence, it's also about who settles the paper. Whoever redeems the bond ends up as the creditor, not the debtor. In simple terms, the system keeps score in dollars, not morals. When you settle that bond, you're not paying a fine, you're balancing the books. The irony? The very account they draw from belongs to you, tied to your social security number, without the dashes. That's your mortmain account, Latin for dead hand, an account that can't run or hide, but holds your credit potential. Footnote. The section explains how court cases are underwritten by unseen bonds and how settlement transforms liability into credit. 2. The mortmain mystery. It's called mortmain because the state keeps your assets frozen in a legal coma. They operate down in Puerto Rico, a place conveniently outside U.S. constitutional jurisdiction, because that's where maritime law rules the waves, not the Constitution. So what does that actually mean? It means every so-called public debt is really a private asset in exile. Your assets are being reinsured, repackaged, and held under color of law. It's like having a mansion you're forbidden to enter because the butler changed the locks. These accounts don't function as trusts in the traditional sense. They're more like quarantine vaults, off limits to their rightful owner. The courts, acting as beneficiaries, use these to fund operations under maritime codes. Footnote. This section highlights how mortmain accounts represent immobilized private wealth held under maritime law outside constitutional oversight. 3. Statements versus bills. Here's where the comedy of errors begins. That bill from your utility company? It's not a bill at all, it's a statement. An allegation, a claim, an invitation to play financial ping pong. A statement says this is due, but a true bill says this has been paid. So what does that actually mean? Until you accept the statement and settle it, it's fiction. It's a script waiting for an actor, you. When you accept for value and post payment using your exemption account, you discharge the fiction. The negative credits you release balance the positive charges on their books. Refuse to play, and they escalate. Dishonor leads to third-party debt collectors, new bonds, and more fiction stacked on fiction. The trick isn't to argue, it's to settle. Remember, creditors don't argue. Footnote. The section differentiates between statements, claims, and true bills, settled debts, emphasizing that accepting for value neutralizes fictional liabilities. 4. Private bankers and living men. Here's the punchline: you're the living person, but the system only deals with paper entities. The bridge between worlds is your individual banker, your authorized interface. He represents your private estate in the public realm. So what does that actually mean? It means you can't walk into a court as flesh and blood and expect to be heard. You need a fiduciary, someone, fictional, who can speak their language. You have two accounts, your estate, the source, and your trust, the channel. Your banker operates both, managing the Social Security CUSIP account that holds the credits tied to your birth certificate. Forget the myth of needing a Secretary of State's blessing. You've always had authority. The state officer is just a corporate secretary. The living creditor outranks the hired clerk. Footnote. This section explains how one functions as both principal and fiduciary through a designated individual banker to interact with public entities. 5. Settling without fear. Fear is the state's favorite currency. Most people freeze when confronted with official paperwork, convinced they're powerless. But remember, power hides in understanding. When you settle a bill using your exemption account, You're not stealing, you're performing bookkeeping. So what does that actually mean? It means the IRS isn't your enemy, it's your clearinghouse. Submission processing centers, from Austin to Ogden, exist to balance public and private ledgers. You can redeem value from your certificate of live birth, just like drawing equity from an untapped account. The catch? Keep it private. Registering anything with the state gives them jurisdiction. Keep it unregistered, and it stays yours. Footnote. This section clarifies that private settlement through internal treasury channels operates lawfully within bookkeeping principles, not defiance. 6. The Law of Merchants. This system isn't new, it's ancient. Babylonian scribes were clearing ledgers long before the first gavel struck. From Egypt to Rome, the law of merchants, the lex mercatoria governed trade, bonds, and debt redemption. The modern courtroom is just the latest theater for the same act. So what does that actually mean? When the judge says settle with thy adversary quickly, he's quoting a 2,000-year-old accounting rule, not moral advice. The one who balances the bond closes the case. Footnote. This section connects modern financial jurisprudence to ancient mercantile systems, emphasizing settlement as universal law. 7. The missing link, the individual banker. Many got lost chasing UCC filings, apostilles, and ceremonial paperwork. The missing link wasn't bureaucracy, it was identity. The moment you declared your individual banker, your private bank was born. The IRS recognizes the structure because it mirrors their own accounting logic. So what does that actually mean? It means you've always been the underwriter, you just forgot to claim your seat. Once the private bank is established, all else falls into place. Form 56 for fiduciary authority, W8 for status, 1099A for transfers. The pieces fit once you realize you're not the debtor, they are. Footnote. This section identifies the individual banker designation as the functional key to operating a lawful private financial interface. 8. The rule of settlement. Stop arguing. Arguing signals ignorance. Settling signals mastery. The system only fears one thing, a creditor who knows how to close. So what does that actually mean? It means the ultimate goal isn't to fight, it's to reconcile. Redeem the bond. Settle the claim. Walk away with peace, and credits. Footnote. This section concludes that comprehension and lawful settlement, not conflict, restore control over one's financial and legal standing.